But let's talk about these two cases that came down today. The first being, of course, I am of course very excited in the way that it was the ruling came down, but I'm going to miss talking about King V Burwell.
I thought of you when I saw that news, and I felt just a sort of tinge.
You know, between Mila going away for camp for 2 weeks this weekend and King V Burwell leaving our consciousness forever, there's going to be a void, but it's going to be a happy void. I mean, let's not get too far into it.
Partially happy.
We'll get to the reactions. All right, I'm just going to briefly cover the cases, and then we'll get to the reactions because the reactions are almost as fun. The King V Burwell, I think, hopefully, you're all familiar with this case by now. It was brought by a conservative legal group, and that's fine. That's what they're done. We know we've talked about the plaintiffs. The most recent, I should say, I think it was King, right? Or was it Halbig? This guy didn't even realize what the case was about. Most of these people didn't even realize what the case is about, but that's all fine. I really don't think that's too, I don't have a problem with that. But the bottom line was that these conservatives were bringing a case based upon four words in the Affordable Care Act law, which said that essentially an exchange established by a state is eligible for federal tax subsidies. And if it was the case that only a state exchange was eligible for tax subsidies, then in this instance, about 34 states whose exchange was run by the federal government, established by the federal government, would not be eligible for those tax subsidies. And the law, the whole scheme, would immediately fail, at least for the private insurance side of it. And millions of people would lose their health insurance. John Roberts, in his opinion, wrote what is really the most obvious response to that, which is, why in the world, if we are to divine intent of this law, right? Because if it was as simple as simply saying, obviously there's some contention as to what the law means. And so our job is to divine the intent of this law. And if the intent of this law was to be that only states who have exchanges established by the state, as opposed to with the federal government, if that was the case, then they would have written a law that would not work from day one, and that makes no sense. So he writes, in this instance, the context and the structure of the act compel us to depart from what would otherwise be the most natural reading of the pertinent statutory phrase. In other words, sometimes common sense is actually not as a sophisticated and nuanced look as we need to navigate through the world. Okay? Yes, a 5-year-old or a 7-year-old, let's say, would read the law in one fashion, but a grown-up understands that sometimes things are fashioned and written in a way that they're not meant to be, and so we need to use grown-up brains. He went on to say, Congress passed the Affordable Care Act to improve health insurance markets, not to destroy them. If at all possible, we must interpret the act in a way that is consistent with the former and avoids the latter.
Right.
I mean, seems reasonable, right? Well, not if you're Antonin Scalia. Here are some of Antonin Scalia's responses to the ruling in King V Burwell. He's so angry, ladies and gentlemen. And you got to feel for him a little bit. Let's now read Antonin Scalia's his response to King V Burwell. Please, Matt, turn up my computer. All right. Words no longer have meaning if an exchange that is not established by a state is, quote, established by the state. Under all the usual rules of interpretation, in short, the government should lose this case, but normal rules of interpretation seem always to yield to the overriding principle of the present court. The Affordable Care Act must be saved. You know what I got to do is get my daughter to read these. Because it does sound sort of like this music's not working. That's
just basically like, whatever, fine, just keep it.
Today's interpretation is not merely unnatural, it's unheard of, said Antonin Scalia in his dissent. And the cases will publish forever the discouraging truth that the Supreme Court of the United States favors some laws over others and is prepared to do whatever it takes to uphold and assist its favorites.
Its favorites. That's great.
We should start calling this law SCOTUS Care.
Ooh.
Burn.
I was listening to Rush earlier, and that's what he said.
Burn. You got burned.
He should just start quoting it.
It's honestly, it does sound like I got to get Miles.
This morning on Fox and Friends, there was this great point Steve Ducey made. That's like Antonin Scalia. He is just getting more and more honest.
Right. And then you're just going to have Dennis Miller come out and go, this is the way that you read the thing. I guess we should understand it like it's hieroglyphics written on the side of Zarathustra's wall.
I didn't realize this was Derrida class at Sarah Lawrence. I thought what you read when you read. Ba 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 ba.